Thank you very much, Ms. Perez. Let me, before we go into a few questions, say a few words about the disclosure yesterday of the article that was published in Sojourners magazine. Let me tell you that I have taken a look at the standards of the committee and believe that you are in total compliance both with the letter and spirit of the rules and law. You submitted to the committee an article which had been submitted for publication in May of this year, before your nomination to the Second Circuit, and that article was published online yesterday. We have the letter of transmittal from you with the article in a timely fashion. Question 12A of the Senate Judiciary questionnaire requires nominees to provide all published materials, including materials published on the internet, to the committee. The question does not, however, require nominees to produce unpublished materials, so you complied completely as soon as it was published. I might also say that I read it, and having read it, some may take exception, and I certainly believe they will. I would gladly give your article as a speech from me personally on the floor of the Senate any day of the week. I agree with what you said to the letter, and I would also say that it is factually correct in every aspect that I'm aware of. So we may disagree on policy. That's the nature of this United States Senate and our body politic, but in terms of the article itself, as I said, I believe that it's accurate, and I would embrace it. The only reference to the Republican Party was in the title, and that you said was not your choice, but the editor's choice. It speaks of issues in state legislatures without any partisan identification on that. But let's go further with this. You've worked with the Brennan Center, and Senator Grassley raised a point which is entirely valid. We raise this point all the time. Do you come to this really awesome responsibility with a bias? I think the world of Justice Brennan and what he did on the Supreme Court. As a matter of fact, I think there's a quote in here. Let me find it because it's worth remembering. There's a quote that said that Justice William Brennan was probably the most influential justice of the century. And the source of that quote was Anton Scalia. So Brennan himself was a well-respected man, and I have turned to the Brennan Center many times when there are questions of policy that they have looked into. What would you say of your own philosophy? Textualist, originalist, I don't know all the terminology of the Constitution. Please, the floor is yours.
Certainly, Senator Durbin, thank you so much. I think the first place you start when examining the Constitution or a statute is with the text. It is the most probative example of how it should be interpreted. I think if on its face the text is not clear, you would then look to precedent, and if confirmed, I would be looking to precedent both from the Supreme Court and the Second Circuit. If that still doesn't answer the question, you look to canons of construction. You perhaps approach a legislative history, but there is more than 230 years of jurisprudence in this country, and there is relevant and probative jurisprudence on quite a number of issues. But you start with the text, sir.
Members of the Senate and many others swear allegiance to that Constitution, to defend it. People have given their lives in defense of that Constitution. And yet I would say, my own personal opinion, as great a document as it is, and it is great, it is not perfect. Its treatment of African Americans, women, and others reflected the mores and standards when the Constitution was written. So I would just say, and you don't have to comment, that I am not a literalist when it comes to characterizing African Americans as two-thirds of a citizen, and not including women in the right to vote. That, to me, is a reflection of the times, and thank goodness those times have changed. Speak to me, if you will, though, about the right to vote. That is the central issue that we're discussing in so many aspects. A group of Texas legislators decided to come to Washington so that they wouldn't make a quorum in Texas over controversy involving a voting rights law. People feel very intensely about it. Comment on that, if you would.
Senator, the right to vote keeps us free. It protects us from tyranny. It is preservative of all other rights. And as an advocate, I have been duty-bound to ensure that the promises this Constitution makes about being able to participate in your own self-governance is actualized. The position before you I seek is one of a different role, one in which I would not be involved in questions of policy, but merely evaluating the laws that were put before me alongside the record that the parties put in. But the fundamental core of what is great about our country, the Constitution and the promises that it makes that we all deserve a free, fair, and accessible vote, is something that is timeless and something that is bipartisan.
I know the answer to the question I'm about to give is very simply yes, but I'm going to ask you if you would expound on the notion. Have we had any difficulty in the history of this nation in providing the right to vote to all Americans?
Yes, sir. There are times where we have not lived up to the great ideals of the Constitution, and I'm very proud to say that we are improving on that, but it requires vigilance, and it requires all of us Americans being part of the we the people in order to make and continue to make our union more perfect.
Thank you. Senator Grassley?
Yeah.
Well, thank you very much, Ms. Perez, for appearing before the committee. You may receive some written questions, which we hope we will provide timely answers to.
I will do so, sir. Thank you.
Thank you very much. I'd like to let the staff prepare for the second panel and ask them to please step forward. I'm going to ask Senator Coons to take over while I go vote and return. Thanks, Senator Ossoff. I think I'll be the last to wrap up, and I just have a question for the aspiring judges, and it relates to my own experience here serving in Congress. It was about 30 years ago when we declared a war on drugs, and the reason that we acted as we did had a lot to do with the advent of crack cocaine. The arrival of this new narcotic was scary. It was very cheap, very addictive, and very destructive to many people. And during the course of our debate on this issue, I was in the House at the time, there were incidents that occurred that gave us a sense of immediacy, all the discovery of this drug and such. There was a case that did not involve crack cocaine, but had a great deal of publicity involving a Maryland basketball player, Len Bias. And as a consequence, we did something dramatic. We created a sentencing guideline for crack cocaine at 100 times the level of powder cocaine, 100 times. The idea was that if we came down that hard, that fast, that dramatically, that it would really break the back of crack cocaine in terms of its infiltration into America. We were completely wrong, completely. The number of addicts increased. The price of the drug on the street went down instead of up, and we started filling our prisons, primarily with African-American defendants. Dramatic increases in our federal prison population to levels we'd never seen before. And some of the sentencing that went on as a result of it, we look back on and say, how could we have done that? A man named Alton Sims in the Chicagoland area. 3 nonviolent crack cocaine sales. Life in prison. Life in prison. And many others just like it. They went way beyond any deterrent effect and really reflected our desperation to bring this under control. Many judges commented as they were forced by our mandatory minimum sentences and other guidelines that they didn't feel justice was being served in their courts when they imposed these sentences. I knew several of those judges personally who talked to me at the time. Since then, I've tried to correct my mistake, and we have passed 2 reforms of the sentencing law. Senator Grassley was my partner in the most significant one, the First Step Act, and fair sentencing before that. I'd like to ask the 4 of you who are aspiring to these district court judgeships, what lesson we should have learned from this experience? Judge Pan?
Thank you for the question, Senator. I think that you raise a question of deep significance that affects many people. And the lesson that I've learned from what you've just said is that the legislature can learn from mistakes and seek to correct them through the legislative process. And I think that's a very positive thing for the legislature to undertake. Of course, as a judge, this is not the kind of thing that we can address as a policy matter. But I think sentencing considerations before judges are done on a case-by-case individual basis, and we are required to look at the facts of each case. But from a judge's perspective, I think that making the sentencing guidelines no longer mandatory and now voluntary is another thing that's been helpful in this regard.
But there are sentencing enhancements that are suggested by the government in many cases. Does that come into play? That's a discretionary decision by the judge.
Yes, and of course, as a judge, performing the function of sentencing, which is so important because the liberty of another person is at stake, a judge must consider all of the relevant factors, including the requests of the government, and weigh all of that under the totality of the circumstances.
Judge Williams?
Senator, my understanding of how, as a judge, if confirmed as a district court judge to deal with it, is informed by my handling of some misdemeanor cases, squarely not on point with addressing the crack cocaine issue. As I agree with Judge Pan, that's an issue for the legislature. What we have learned, what we learn and know as judges, is that we have guidelines to follow. 3553A allows judges to interact with a very, very seasoned and skilled probation office that helps inform and supply us with the information necessary for us to work through those guidelines on individual cases. So I've done that in misdemeanor cases for individuals charged with crimes, and should I be confirmed, I look forward to working with our many talented probation officers as I work through the Sentencing Act in the role of sentencing as a district court judge.
Judge Merriam?
Thank you, Senator. When I was in the Federal Defender's Office, I was there when the initial changes in the crack powder disparity went into effect, and I was heavily involved in the process of organizing the district, which meant everyone. That was the prosecutors and the probation office and the judges and the marshal service and the defense bar to make those changes applicable to the clients where it was appropriate as quickly and efficiently as possible, to try to do the justice on the ground that the legislature had seen fit to put in place. And those changes have certainly made a real difference over the years. But at the end of the day, we're bound now, other than by the mandatory minimums, by 3553A, which is, as Judge Williams referenced, very broadly encompassing the kinds of factors and the kinds of considerations a judge can take into account. And that discretion is an awesome one and an important one, and allows judges, I think, to work within the law to try to do justice.
Ms. Cobb?
Thank you. It's hard to improve upon the responses that have been given, but I think what struck me most about what you said is the fact that this body was paying attention to what was happening in the courts, and I think that's extraordinarily important. When laws are passed, particularly that provide criminal penalties, whether they be mandatory minimums or otherwise, to pay attention to kind of what the effect is on the ground once those laws are implemented. And I know that the Sentencing Commission does some work in compiling statistics, but I really think it's important to, continue to pay attention to what's happening after these laws are passed.
Let me just add one other thing that has changed the conversation. 20 years ago, 15 years ago, if you would have said, oh, did you hear about that person who overdosed on drugs last night? The most common answer would be, no, I didn't. Was it an African-American, inner city, man between 20 and 35? You would have been right in most cases. Not anymore. When we talk about drug overdoses now, it could have been that cheerleader at the all-white high school in the suburbs. And drug addiction has now reached every corner of America. And we're starting to look at it anew. It is no longer just say no. We realize it is a medical problem, a disease. We haven't responded with the adequate resources to deal with addiction. I hope we will in the future. But the conversation on drugs has changed in America because the victims have changed pretty dramatically. That is going to be part of the reality that I hope you soon will be dealing with in your new positions. I thank you for your cooperation at this hearing. It's been an important one. You may receive some written questions in the near term. Is there anything else I need to do formally? Wants me to read it, make sure you understand this. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, July 21st. The record will remain open until that time to submit letters and similar materials. And with that, the hearing is adjourned. Thank you all very much.